Hi and welcome to this very interesting episode of the SCC Online Weekly Rewind series, wherein we will be discussing two top stories and the long-awaited decisions. One is from the top court of the country with regard to sedition, Section 124A IPC, and the other is from Delhi High Court with regard to criminalization of marital rape. Also stay tuned with us to know the winners of this week's SCC Online quiz. In the petitions challenging the constitutionality of Section 124A of the Penal Code dealing with the offence of sedition, the Supreme Court has urged the state and central governments to refrain from registering any FIR, continuing any investigation, or taking any coercive measures by invoking Section 124A IPC while the sedition law is under consideration. Further, all pending trials, appeals and proceedings with respect to the charge framed under Section 124A IPC be kept in abeyance. The court made clear that adjudication with respect to other sections, if any, could be proceeded if the courts are of the opinion that no prejudice would be caused to the accused. If any fresh case is registered under Section 124A of IPC, affected parties are at liberty to approach the concerned courts for appropriate relief. Interestingly, Union of India has agreed with court's prima facie opinion that the rigors of Section 124A of IPC is not in tune with the current social milieu and was intended for a time when this country was under the colonial regime. Whether marital rape exception should remain in the statute. In the most awaited Delhi High Court decision, the division bench passed a split verdict wherein Justice Rajiv Shakdar expressed that women in most parts of the world are treated as individuals free to enter into contracts in their own right, but when it comes to sexual communion with their husbands, their consent counts for nothing. Justice Shakdar opined that the classification between married and unmarried women is unreasonable and manifestly arbitrary, as it seems to convey that forced sex outside marriage is real rape and that the same act within marriage is anything else but rape. Further, he added that in a gang rape involving the husband of the victim, the co-accused will face the brunt of the rape law, but not the offending husband, only because of his relationship with the victim. A married woman's ability to say no to sexual communion with her husband when he is infected with a communicable disease or she is herself unwell finds no space in the present framework of rape law. Thus, the rape law as it stands at present is completely skewed insofar as married women are concerned. Justice Rajiv Shakdar of Delhi High Court ruled in favour of striking down the marital rape exception. Disagreeing with Justice Shakdar's opinion, Justice Hari Shankar opined that the act of sex when it takes place between parties who are joined by marriage declares the impugned exception is no case of rape. He observed that the emotional element of the act of sex when performed between a husband and wife is undeniable. The marital bedroom is inviolable, a legislation that seeks to keep out from the parameters of such a relationship any allegation of rape, in his view, is completely immune to interference. In his view, introducing into the marital relationship the possibility of the husband being regarded as the wife's rapist if he has, on one or more occasions, sex with her without her consent would be completely antithetical to the very institution of marriage. Stating that the expectation of sex of the husband with his wife is a legitimate expectation, Justice Shankar held that challenge laid to constitutional validity of Exception 2 to Section 375 and Section 376 IPC and Section 198B CRPC fails. In a case where a judge was accused of misconduct, the Supreme Court held that showing undue favour to a party under the guise of passing judicial orders is the worst kind of judicial dishonesty and misconduct. 12 charges were levelled against the judge who had, while deciding a batch of matters under the Land Acquisition Act, awarded enhanced compensation, which is multiple times more than the investments made by the subsequent purchasers of the acquired lands, with a view to unduly favour such subsequent purchasers. Finding enough evidence of misconduct against the judge, the court expressed, a judge must decide the case on the basis of the facts on record and the law applicable to the case. If he decides a case for extraneous reasons, then he is not performing his duties in accordance with the law. As often quoted, a judge, like Caesar's wife, must be above suspicion. While rejecting an appeal to quash proceedings under Section 138 of the NI Act at pre-trial stage, the Supreme Court held that when there is legal presumption, it would not be judicious for the quashing court to carry out a detailed inquiry on the facts alleged without first permitting the trial court to evaluate the evidence of the parties, observing that the consequences of scuttling the criminal process at a pre-trial stage can be grave and irreparable. The bench stated that, at any rate, whenever facts are disputed, the truth should be allowed to emerge by weighing the evidence. Otherwise, the accused may get an unmerited advantage in the criminal process. In another women-centric decision, Kerala High Court addressed whether employers are obligated to ensure that delivering and raising a child shall not be detrimental to female workers' career. In this case, maternity benefits were not being allowed to female workers since their services were not regularized. Kerala High Court, coming to their rescue, expressed that becoming a mother is the most natural phenomenon in the life of a woman. Hence, employer is to take all steps possible to ensure that they are sympathetic to the cause of the female officer so that she can achieve her potential in the workplace, and the time spent by her to deliver and raise her child shall not be detrimental to her career or her prospects. Noting that the nature of work assigned to women cannot be carried from home, Karnataka High Court held that, as per Section 5, Subsection 5 of the Maternity Benefits Act 1961, work from home after availing the maternity benefit could be given only in a case where the nature of work assigned to the women is such that it is possible for her to work from home. To read this very interesting case, please check out the SCC online blog. Statement that Kashmir is under occupation of armed forces and people of Kashmir reduced to slaves will be protected under right to freedom of speech and expression. Stating that the intention of a person can be gathered from the words spoken or written or other expressions, Jammu and Kashmir and Ladakh High Court expressed that expression of outrage at the negligence and inhuman attitude of the security forces, police and establishment would come within the ambit of freedom of expression of an individual, which includes freedom to criticize the government of the day, which is permissible under the law, but the same may not be the position if an individual questions the fact of a state being a part of the country by using the expression occupation of military or the people being slaves, etc. Bench remarked that it is one thing to criticize the government for its negligence and express outrage on the violation of human rights of the people, but it is quite another to advocate that the people of a particular part of the country are slaves of the government of India or that they are under the occupation of armed forces of the country. Read the full story at SCC online blog. Let's move on to the legislation updates. The Securities and Exchange Board has notified SEBI Collective Investment Schemes Amendment Regulations 2022 to further amend the SEBI Collective Investment Schemes Regulations 1999. The amendment inserts a definition of designated employees. A new provision, Rule 9B, has also been inserted, dealing with the voting rights of no collective investment management company. The central government, on the recommendation of the Reserve Bank of India, declares that the provisions of the subsection 1 of section 15 of the Banking Regulation Act 1949 shall not apply to a banking company for a period up to 31st March 2026 insofar as it relates to the treatment of unamortized expenditure on account of enhancement in family pension as set out in the circular issued by Reserve Bank of India. Central government has notified the following events as sporting events of national importance. First, all Olympic Games. Second, Commonwealth Games. Third, Asian Games. Fourth, events relating to cricket, tennis, hockey, football, badminton, kabaddi, World Cup, Khelo India Games. In this week's SCC online quiz, we had asked how many subtopics are covered under the head Service Rules under curated topics on SCC online web edition. The answer is 5. First, Armed Forces. Second, Banks and Debt Recovery Tribunals. Third, IBBI. Fourth, Press and Media. And fifth, Case Law. The winner is Antrix Kipadia. Congratulations. Thank you for your time, everyone. This is Devika Sharma signing off for this week.